Court Uncut, what the people want.
We're here in cause number 19-32623, and we have had some discussions in the back that I think we need to put on the record with regard to the case and where we are. We have, first of all, sir, you're Dalvius Williams.
Yes, ma'am.
And Mr. Williams is here with Mr. Rojas. Mr. Smith is here on behalf of the state. There is a second amended motion to revoke unadjudicated probation. So we've been here on the motions several times. On that first amended motion, we, back in December, on December 17th of 24, had a hearing where Mr. Williams pled true to counts 1, 2, and 3 in that first amended motion. At that time, there was an agreement for a cap of 4 years, and then we were going to reset that for a hearing. Between the time that we set that for a hearing, the state filed a second amended motion to revoke unadjudicated probation. On March 25th of 25, we were here, and Mr. Williams, that second amended only alleged one more allegation, which was count 4, and he entered a plea of not true in that count. And so because the new allegation, I'm not going to accept the plea agreement of the cap of 4 years because there's a new. So I will allow, if Mr. Williams wants to withdraw his pleas of true to 1, 2, and 3. I can go through those again and get pleas today on those, and then we can go forward with what we have today. And then if I feel like there needs to, it's my understanding, Mr. Smith, for today, you have witnesses with regard to proving up count 4 only. Is that correct?
That's correct.
So what we can do today, depending on what those pleas are, either way, we'll go forward with what we have because there's witnesses here. And then if I feel like I need to postpone the hearing to another date for the state to prove up more, then we can do that then. So, Mr. Williams, the best you can, I need you to raise your right hand, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. You can put your hand down. And so, Mr. Rojas, what is y'all's position?
Judge, I think after discussions with Mr. Williams, I think he would like to withdraw his plea of true to count number 3.
Okay. So just to go back, count 1, Mr. Williams alleges that you violated your probation by failing to report to the probation department October 25th and December 15th of 2022. You had previously pled true that was true. And do you want to continue to plead true to that count?
Yes, ma'am.
Okay. And then count 2 alleges that you're behind in your court assessed fees as of January 4th of 2023 in the amount of $3,638. You previously pled true to that count. And do you want to continue with your plea of true to count 2?
Yes, ma'am.
Count 3, which was in the added in the first amended motion, alleges that you committed the offense of evading arrest or detention July 14th of 2024. You had previously pled true to that count, and do you want to change your plea of true in that count?
Yes, ma'am.
You want to change your plea to not true?
Yes, ma'am.
Okay, so we'll enter a plea of not true to that count. And Mr. Smith, I know you weren't prepared, I guess, for that, but have y'all had any contact with the officer? I would think that would be a one witness.
It's actually several witnesses,
Okay.
Judge. They're going to serve a warrant at his house. There were 2 officers in the back that see him come out of the back of the house. when they're
Okay.
knocking on the front door, so we need both of them.
Okay. Okay. All right. So we'll see where we get today then. Mr. Williams is on probation for possession of a controlled substance, and that hold on a second. Let me see. Which was a 3rd-degree felony, correct? No. That's
Yes,
been,
Judge.
oh, it was as well. I've got the indictment pulled up from the injury to a child. That's a third-degree felony. But that possession of a
Possession is a
controlled
third degree
substance
as
is a third degree as well. So the range of punishment is between 2 years and 10 years. And Mr. Williams, I also want to make sure you understand that if we go forward with this motion, and I do end up revoking your probation, then later, if the state does prove, so we have the injury to a child, that new case, if you're found guilty in that new case, then the punishment could be stacked. Do you understand? Do you understand that? Okay. Mr. Rojas, you've gone over all of that with him, correct? And it's also my understanding that y'all had, even in the back, Mr. Williams' mom in the back to go through everything, what his options were and all of that this morning. Is that correct as well?
That's correct, Your Honor.
Okay. What if any offers? I want to make sure Mr. Williams on the record rejects anything that's been offered.
We had offered 4 years in this case, Judge, and he is rejecting that offer.
Did that include an offer in the injury to a child?
Actually, I offered 4 years in both cases to run concurrently.
Okay.
If he went today.
Okay.
He said no. And I told him that if he didn't do that, if we go to trial on the new one, I would move to stack that case on whatever he gets in this case, and the 4 is off the table in this case.
Okay.
Just gonna have just a few. I apologize, Judge. I didn't hear what the last part. Did Mr. Smith talk about the 4-year offer for today to the possession of a controlled substance? And if he were to be tried in the future, if he were to be convicted for the injury to a child, that case would be stacked? Did you say that?
He would request it, and it's up to me. So anytime the state asks for a case to be stacked, it's up to the court to do that. So it's not up to a jury. If you go to a jury trial on that injury to a child, what would happen? Let's say you go forward today, we have this hearing. If I revoke your probation and give you any time in prison, then the next step would be to set that injury to a child for a trial. And then if you're found guilty in that case by a jury, then what the state is saying is that they would ask me then to stack that, whatever sentence you might get, if you get a sentence, on top of what happens today in the motion to revoke probation. Do you understand? Okay. And so your options are today, if you wanted to go forward with a plea in both of your cases, plea of true in that motion to revoke for a 4-year sentence, plea of guilty in the new injury to a child case for a 4-year sentence, with the agreement that those sentences would run at the same time. You don't have to do that. We've got witnesses here. We'll go forward with the hearing. Just want to make sure you understand what your options are today that you won't have after today, and what your consequences could be if you go to trial and if we go forward. And nobody's trying to talk you into anything. I just want to make sure you understand it all. Does that make sense? Okay, so you understand everything that's been offered and what what you could do today and kind of where we're about to go, right?
Yes, ma'am.
And so what do you want to do?
Plead true to the first, but not to the injury to the child.
Okay, then we'll go forward with this hearing.
This for the first one, not this for this whole person.
So Judge, Mr. Williams is telling me that he will take the 4-year for the possession and let the court decide in the future if he gets convicted whether that new charge will be stacked or not. So he wants to take the 4 years today, if that's still on the table.
On the motion to
On the motion to
revoke,
revoke.
without pleading
Without
true.
pleading true to the injury to a child, which is one of, I think, one of the options we have.
I mean, that's up to you. I don't. It's, I mean, we can go forward. He didn't, I mean, you've got whatever. I mean, I think, well, I'm not going to get into y'all's negotiations, but typically part of the agreement is because you're not going to have to go have a trial, and they're not going to have to go through
That's
bringing
why I'm
everybody
thinking
back
if
here
I had
again
to
for a trial.
Do this in a trial to a jury, I'd just assume he'd be up for the full range in this one.
Okay, so there's not going to be any offers if you don't do both. Does that make sense? We're just going to go forward on the motion to revoke probation, and it's just up to me. Okay? Okay, all right. Previously, we all received an updated pre-sentence report. That was, I think, after those initial pleas of true to counts 1, 2, and 3. I don't think there was any other report updated since that one. Does everybody have that updated report?
We do.
Okay.
Your Honor.
All right, so then we've got pleas of true then to counts 1 and 2. And Mr. Smith, you may call your first witness with regard to count 4.
State called Shelby Herd.
Good morning, ma'am.
Good morning.
Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, ma'am. You can have a seat. And tell me your name again. Was it
Shelby Herd.
Herd? And if you'll just pull that microphone down in front of you, get a little closer. There you go. And is the button on down there? Do you see on the left?
It's green.
Okay. And so, Ms. Hurd, just make sure when you're answering the questions that you can speak loudly and clearly so everybody can hear you.
Yes, ma'am.
Also, if it's a yes or a no, be sure to say yes or no, not just a head nod or an uh-huh,
Okay.
so the court reporter can take it
Yes,
down.
ma'am.
Thank you. Mr. Smith?
At this time, I'd like to invoke the rule.
Okay, so who else, Mr. Smith, do you have that are here as witnesses? If y'all will please come forward, whoever's a
We have
witness.
Wana Wilson, Sharita Henson, and Detective Key.
All right,
And I have one witness outside, Dana Wilson.
Dana Wilson.
Yeah, I'm sorry, Williams.
Dana Wilson. Just a minute.
y'all can just kind of come up a little bit and give everybody space. We'll have one more coming in, then I'll get you. All right, everybody, good morning. So if everyone would please raise your right hand. Do all of you solemnly swear or affirm that the testimony you give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. So you're all being placed under the rule. Some of you know what that means already, but it just means that you can't be here in the courtroom during anyone else's testimony other than obviously your own. You cannot discuss your testimony or the testimony of anyone else involved in the hearing with anyone other than the lawyers or the investigators. And you also cannot don't get on your phones and watch anything on YouTube either, okay? All right, if y'all will please all step outside. You may proceed.
Good morning.
Good morning.
Ms. Hurd, what do you do for a living?
I'm a daycare teacher for pre-K 3 at Amina Florence Center.
And that's here in Beaumont, Texas?
Yes, sir.
And how long have you been working?
Since August, because I was at the school, but then it was like a week after school started, I started back working at the daycare.
Okay. And you have an opportunity or have had an opportunity to watch or to care for the Williams children?
Yes, sir.
How many of them did you actually work with?
4. 3 in the morning towards the evening, and then the older 2 towards the afternoon once they make it from school.
Okay. So you basically got to see most of the kids.
Yes, sir.
Now, Xavier, are you familiar with Xavier?
Yes, sir.
How would you describe Xavier to the judge?
He's a very energetic little boy, very sweet.
Okay. Is he autistic?
I wouldn't say he's autistic. I know he has hearing problems, but he's very smart.
Is he verbal?
Yes, sir.
Does he communicate well?
Yes, he talks very low, but if you like put your head down to hear him, you can understand what he's saying.
Okay. Now, the day that all this came up, was that October 28th of 2024? It was a Tuesday, you recall that?
I'm not sure of the exact day that it happened.
Okay. Well, did something get your attention with the
Yes, sir.
What caught your attention with the Xavier?
We was outside taking a walk in the parking lot, and I noticed above his shirt that he had like a few scratches on his upper back.
Did you do any further investigating on that?
Yes, sir.
Did you find marks further down below his collar under his shirt?
Yes, sir.
I approach you, Judge.
Yes.
I'll show you what's been marked States Exhibits 1 through 7. Do these appear to be what you saw?
Yes, sir. Yes, sir.
These photos fairly and accurately depict Xavier's body when you saw him on October 28th.
Yes, sir.
Now we go over States Exhibits 1 through 7 into evidence.
No objection.
1 through 7 are admitted. You could switch that over to Elmo or whatever you want to do.
I was just going to show you, Judge. What did you do when you saw those marks on Xavier?
I reported it to the front office
And why did you do it?
because working in childcare, I know that you do have to report stuff like that as neglect or abuse.
So, you reported that and felt like that was your duty under the law to do.
Yes, sir.
Did you speak to Xavier and ask him how they got those marks?
Yes, I did.
And what was his response?
He told me the sister, because I know she's very feisty, as kids are.
Did you feel like those marks could have been made by the sister?
I'm not too sure.
Pass witness, Judge.
Mr. Rojas?
I'm sorry, who told you that the marks were made by the sister?
Xavier.
He did himself. And do you know which sister he was talking about?
Desire.
And how old is she?
I think maybe 5 or 6, if I'm not mistaken.
And you
How
said-
old was Xavier? Did you?
He's 3.
Okay. At the time of this, was he?
He was
Probably.
2.
Okay. All right.
No, yeah, I think 2.
Okay.
Because I think he just turned 3 in December, if I'm not mistaken.
Thank you.
Okay, and you said it was Desire?
Yes, sir,
And at that time, she would have been 5 years old?
if I recall.
And you said she's feisty?
Yes,
What's that mean?
she's very angry and she gets mad fast.
Okay. You've seen her get mad before?
Yes, sir.
And when she gets mad, what have you seen her do?
She throws her body against the wall. She be fighting with the other students at the daycare.
Okay. Have you ever seen her fight with her siblings at the daycare?
With her sister, yes, but in the afternoon, she don't be with the little ones. So, but her and the sister do be together in the afternoons.
Okay. You say in the afternoon, what about in the morning?
In the morning, they be at school.
Okay. So I think in the report, you witnessed this on a Tuesday. Do you remember that?
I don't recall that,
Okay,
actually.
you don't recall. That's all I have.
Thank you. Anything else, Mr. Smith?
Do you remember speaking to the police on that day?
I don't think it was the actual day, but I do remember speaking with a detective.
When you saw the marks on his back, you described them as scratches and bruises. Looked like somebody had looked like to you someone had hit him, and you took Xavier to Wilson and reported the matter, and you said that Xavier's brother told you that he fell off their porch.
Yeah,
Did the brother actually say that?
the brother said that, but Xavier said otherwise.
Okay, so you got two different reports.
Yes,
Did those marks look like they could have been caused by him falling off the stairs?
I'm not too sure how their porch is, but if you fall, you will have scratches on you.
What about, did you feel like the sister had caused those marks?
She could have.
But did you believe that? Did you think that was right?
Yes,
You thought the sister had caused those marks?
yes, being that I work with her and I know how she is when she's angry.
Okay. But you still reported this to the police?
Yes,
Because it's certainly possible that something else caused those marks.
I'm not sure exactly what it was, but I
Have
know
you ever seen the sister make marks on any other child at the daycare like these?
she do be pinching and scratching, and it be similar to it.
This kind of marks, this many marks?
I'm not gonna say that many, but it be similar to the same scratches that he had on him.
You said you've seen her pinch and you've seen her scratch, but you haven't seen that many marks on any child that was caused by her.
It be scratches, but I mean, it may not be that many, but it do be scratches or pinch marks.
Okay.
Cause
But
she
you
do
didn't
have
believe,
nails.
you didn't believe he got the marks from falling down the stairs.
I can't say exactly where he got it from.
And you can't say for sure that the sister caused those marks. You don't know where the marks came from.
Not actually, but either or.
Okay.
So when you saw the marks, you saw them in person, not on the picture, right?
Yes, sir.
And to you, you're calling them scratches.
Yes, sir.
Is that what they were, scratches?
It looked like it can be scratches, or it could be the marks from falling off a porch, cause you're gonna get scratches from
Okay.
falling.
But you're saying they were scratches?
Yes,
Either
sir.
from scratches or from falling off the porch?
Yes,
they were
sir.
Scratches. And then when Xavier told you that the sister, Deja? Desire did it, that was right immediately when you first saw the marks, right?
Yes, sir, we was outside.
And that's before you had a chance even to report it to your supervisor?
Yes, sir, cause I asked first and then I reported it.
Okay. That's all I have.
Okay, let me ask, when you went, do you remember that meeting you had with the police and with Miss Wilson?
Yes,
Do you remember saying it looked to you like someone hit him?
I said it looked like someone may have hit him.
Nothing further.
All right, anything else, Mr. Rojas?
No, yeah.
Thank you, Ms. Hurd. You can step down and be sure to keep in mind all those rules that I gave you before,
Yes,
okay?
ma'am.
Thank you.
Take call to Wana Wilson.
Wana Wilson. And Ms. Wilson, I'll just ask, when you're answering the questions, be sure to speak loudly and clearly into the microphone so everyone can hear you. Also, if it's a yes or a no question, be sure to say yes or no and not just a head nod or an uh-huh, so the court reporter can take everything down. Thank you. You may proceed.
Ms. Wilson, would you state your name and spell it for the court reporter?
Wana Wilson, DEWANNA WILSON.
And where do you work, Ms. Wilson?
Amina Learning Center,
And that's here in Beaumont, Texas.
1800 Polk Street.
What is your position with
I'm the new director.
back in October of last year, 6 months ago, what was your position there?
I think I was in training for the director.
Okay. So what is your job description as director there?
So much. Doing counts, sending messages back and forth to parents or whatever, food program, logging in. It's,
You have to be pretty much versed in every facet of that job, is that fair to say?
to be notified, yes.
Now, let's turn your attention to October 29th of 2024, last year. That would be a Tuesday. Did anything unusual happen on that day besides the regular unusual? Since we're talking about a daycare.
And only because I don't really know the dates right now. If it's the incident, okay. The kids were outside playing. One of our other workers was walking with the pre-K 3-year-olds and noticed a bruise. I think it was a bruise on the arm was the first one that she noticed. So they had to go and check him, make sure that that was it. Call our boss, Miss James, and notify her of what was going on. And then she called me. I had to go in, take the pictures, call, see who I had to call. First time having to deal with it, so I don't know.
Let me show you, we're talking about the injuries to Xavier Williams. Let me show you what's been admitted in as states exhibits 1 through 7. Have you look at those? Do those photos appear to be what you observed
Yes, sir.
in that same kind of condition?
Yes, sir. Yes, sir.
So you actually observed those marks on his back?
Yes, sir.
And how would you describe those marks?
Bruises.
Did it,
Bruises, I wasn't sure if it was a belt, a hand, I didn't know what it was, so.
how would you describe Xavier? Are you familiar with him and his?
Yeah. He's a quiet kid, he's a good kid. Very, very smart. You wouldn't know it because he doesn't speak a lot, but he's very smart. If you have him one-on-one and ask him something,
Mhm.
he's a very smart kid.
Is he, does he kind of keep to himself? Is he a little different?
He's a little different. He likes to play. Don't get me wrong. He likes to play. He's a little different. I think he has a hearing with one of his ears, one side of one of his ears. I'm not sure which one it was, but the parents had notified us about it. But he likes to play. He kind of plays a little rough sometimes, but they're 3-year-olds.
Right. Did those marks look like marks that he could have gotten from playing with other kids?
I didn't think so, but then I didn't know.
Did it look to you like those marks could have been some kind of abuse?
No.
Is it your job, I guess, responsibility under the law, if you see those marks on a child, to report them to the police?
Report them to our supervisor, our boss, which is Miss James, and then she tells you what to do from there.
Y'all did call the police that day?
Yes, sir.
And they came out and started their investigation?
Yes, sir. I don't think it was immediately though.
That's nice.
Thank you. Mr. Rojas?
Good morning, Ms. Wilson.
Good morning.
So you said Xavier's a playful kid, likes to have fun.
Yeah.
You observed all the other Williams kids also?
Yes, sir. I worked with all of them.
And the parents' interaction with them, did you observe that also?
Mm-hmm.
I'm sorry?
Yes, sir.
Thank you.
You familiar with Deja, the sister?
Mm-hmm. I've met Deja.
Okay. How would you describe her?
I've only met her as in come and pick up the kids and everything. She seems attentive to come and get them and everything.
So you're not involved in day-to-day taking care of the kids? I mean, you're not watching them constant like the workers are, are you? I mean, do you observe them more than let's say Ms. Herd does?
You know, he's in Miss Herd's class.
Okay.
Well, he's in the next class over, but they were in a class together before they got separated, the 2 teachers.
Okay.
So now he's in the other class.
Do you know, or have you seen Deja be excited before?
Deja?
Deja.
Desire.
Oh,
Desire,
Desire.
I'm sorry.
Oh, okay. I'm thinking the aunt. Okay.
Desire.
Yes.
She
Yes.
does.
I know. I dealt with a Desire.
What have you dealt with Desire?
As far as I've been around, I said I wasn't around before because I thought you were talking about the aunt.
Okay, I'm
But
sorry.
you're talking about
Desire,
Desire, the
yes,
little
ma'am.
sister.
Yes.
Yeah, I'm around them all the time because I'm usually with the after schoolers.
And is Desire excitable?
Yeah, she kind of has an attitude sometimes.
You ever seen her get angry?
Oh yeah.
You ever seen her get physical with the other kids?
I've heard, but most of what Desire is getting mad at, not liking to do what an adult tells her to do.
Okay. So you observed these, so the pictures you were looking at and the injuries you saw, I think Ms. Herd, Shelby described them as scratches. Would you agree that they were scratches?
Scratches, bruises. I wasn't sure
Okay.
because it was, like he said, a Tuesday, and I think like the Monday they weren't there.
So did you only see them through pictures or did you actually see?
I saw, I had to be right there when he took the pictures.
Okay. So you're saying they could be bruises, they could be scratches? Did you talk to Xavier about how they happened? Did you ask him that at all?
We asked Xavier, but Xavier didn't even say it. He didn't say anything about it.
He didn't say anything about it while you were there?
Yeah.
Pass witness.
Nothing part of this witness.
All right, thank you, Ms. Wilson. Keep in mind those instructions that you were given before.
Judge, we'd ask that Ms. Wilson and Ms. Herd be excused to go back to daycare. I think it's kind of an inconvenience for both of them to be here.
Any objection to
No
that?
objection, Your Honor.
Thank you, ma'am. Y'all are both free to go.
Thank you.
You may call your next witness.
State called Sharita Henson.
You may proceed.
Good morning, Ms. Henson. Would you state your name and spell it for the court?
Yes, sir. Sharita Henson, and that's SCHRIETTA, last name HENSON.
And what is your occupation?
I work for the Department of Family and Protective Services. I'm an investigation supervisor.
Okay. And would you describe for the judge basically what you do?
I actually work in the department where we receive intakes regarding abuse or neglect, and we are responsible for putting those cases in the field. That way we're able to investigate abuse or neglect for children.
Now, the investigator that was assigned to the case of Xavier Williams, that was Officer Treviso?
His name is Joshua Treviso. That's correct.
Okay. Is he still with?
He's no longer with our agency. He actually has relocated to another state.
So he's moved off, I believe, North Carolina somewhere.
That's
far away.
correct.
But explain to me, when a case is open, what does it take to open the case?
The agency we actually have a department called statewide intake. And whenever someone believes there is abuse or neglect that has taken place, they can call that 1-800 number. And at that time, they report whatever their concerns are. And statewide intake actually generates a ticket or a case regarding whatever that information is, if it does reach the level of abuse or neglect.
Okay. So a case is reported to the agency, and then an investigator is assigned to go and examine the facts.
That's correct.
Was that done in this particular case?
Yes, it was.
And were those findings put into a report?
Yes, sir.
And does that become part of a file?
It does.
Is that file kept in the course of regular business for the agency?
It is.
And something that other investigators can look at and refer to and count on as this is what we know so far?
Yes, it's considered the history for the family.
Were you able to go over this report in the absence of Officer Treviso?
Yes, I did.
And what is the status of the investigation?
The case is actually closed at this time.
Okay. Was there a finding, I guess for my own benefit and for that of the judge, when you go through the investigation, do you make a finding that abuse occurred or didn't occur? How would you describe that?
We do have a finding on the allegations, and that could either be reason to believe, unable to determine, or ruled out.
Okay, so basically it's, we think so, we don't think so, or could go either way?
Or we don't have enough information to prove either way.
What was the finding in this particular case?
This was a valid case with a reason to believe disposition.
Okay. And that investigation went through talking to the workers at the daycare, talking to the children,
That's correct.
talking to the adults that are in charge of the children.
That's correct.
When you say there was a finding, could it have been attributed to one of the 4 or 5-year-old children causing these marks?
No, sir.
Could it have been the child falling down the stairs?
No, sir.
Was that one of the versions that was given to you?
Yes, it is.
And could it have been an accident?
No, sir.
You felt like those marks were abuse
Yes, sir.
by an adult?
Yes.
Did there appear to be anything suspicious in the accounts given to you by the other children?
Just reviewing the case file, it was identified, and we had several children.
Judge, I guess at this point, I'm gonna object to this being hearsay if it's coming from work, of other workers.
Response?
Well, Judge, I guess technically we could offer the whole file in as a business records affidavit if you court would be so inclined to see that. I just felt like she's referring to what was actually in the report. We don't have that particular worker. It's the same as if a pathologist who does an autopsy is no longer available. We have somebody else review their work and testify to that. So this is basically what we're doing here.
Overruled, go ahead.
You can answer that.
Could you repeat your question?
You can have Ms. Tanner read it back if you need.
I hate to do that, Ms. Tanner, but what was my question?
That's okay.
That's okay, I'll just move on.
Sorry.
Did, as part of that investigation, were y'all looking to see who the disciplinarian in the family would be?
We did ask about discipline, and that was a question that was asked as far as who was the disciplinarian in the household.
And who was the disciplinarian?
Based upon the report that we received from the children during the investigation, they identified Mr. Williams as the primary disciplinarian in the home.
Based on the findings in the report, when you feel like abuse has certainly been committed by an adult, was there a particular type of safety plan that was put into place?
Originally, a safety plan was not put into place because at that time, Mr. Williams was arrested and he was identified as our alleged perpetrator. However, a safety plan has been put into place now that there are different circumstances in that particular case.
And did that involve 24-hour monitoring?
It does.
Is that still going on?
Yes, it is.
Part of the report, did they speak to Anira and Desire?
Yes.
Were those the counts that we were talking about that y'all appeared to be, y'all suspected were suspicious?
I don't recall what you're asking.
Well, one said mosquito bites and one said he fell down the stairs.
Correct.
Did those marks appear to your agency and to you to be the result of either of those two occurrences?
No, sir, not at all.
And did y'all feel like those kids had been coached in their responses to your questions?
In some way.
That's what I'm saying.
Mr. Rojas?
Good morning, Ms. Henson.
Good morning.
Mr. Smith was asking you about whether you thought this could be the work of another child. You said no.
That's correct.
Are you familiar with Desire?
I've reviewed the case file and I've seen her name in that case file.
Have you, has anybody reported to you or in the case file that Desire has anger issues?
I have been informed that there is behavior, like very hyperactive, I should say, yes.
Okay, and was there also in the case file reporting that Desire has lashed out physically against her siblings before?
The case file does reflect that the siblings do have, sibling relationship where they do sometimes become, I wouldn't say, I guess you could say, where they actually have sibling rival, where they actually do engage in some type of play fighting, or sometimes, it's something that has to be redirected, but it's nothing that has been identified other than just sibling playing.
And that came from who?
That was documented in the case file.
Do you know who told the worker that?
The mother,
The mother said the
Miss
kid.
Broussard, that the kids will engage in getting physically aggressive with each other at times, and not using those exact words, but they do fight.
You said that originally there was no safety plan in place, but then due to changed circumstances, there has been a safety plan put in place?
That's correct.
What are the changed circumstances?
The mother has also been arrested
For,
injury to a child.
and that was for this same injury or for a different injury?
I wouldn't know exactly what her charges are, what child, I'm not sure, but I do know it is related to this particular case, yes.
And she was arrested.
Same. It's this, I just want to make sure it's the same.
It is the same.
Okay,
She's a co-defendant.
thank you.
So she's arrested, she's charged with the same
Correct,
charges.
yes.
If you're so certain that it was Mr. Williams, why are they charged against her and why is there a safety plan?
That's not a question that I can answer for you, but I will tell you, as far as our investigation, we did identify reason to believe for Mr. Williams.
Reason to believe doesn't mean that he did it, just as there's some evidence that maybe he did do it, right?
That means that our agency believes that he did.
So if your agency believes that he did it, would you still go and do a safety plan for the mom?
We didn't have her identified as an alleged perpetrator at the time. Mr. Williams was incarcerated at that time, so we didn't feel the need a safety plan was needed. And it's not that we didn't try one, but the family didn't have anyone that we could approve at that time. And we thought that the situation was in a stable position with the alleged perpetrator being out of the home.
There was a point when Mr. Williams was in jail,
Correct.
and mom was still out on the street.
Correct.
No safety plan.
No, there was none.
At some point, he's still in jail. Mom gets arrested for these same charges,
Correct.
and now there's a safety plan.
It is.
How do you explain that?
I cannot, this case is actually in another stage of service at this time, so I can't tell you the specifics of why that was put into place, but if mom is an alleged perpetrator and has been charged on that case, we do follow the court order that says she's not to have any contact with the victim.
What is an FACN?
It's a forensic assessment that is completed by a medical team that specializes in child abuse.
And one was done in this case, right?
I'm not sure.
It's in the file?
It may be, I didn't review that part if it was.
Are you familiar with a Dr. Patricia Beach
I am
and Sheila Lahode?
definitely know Dr. Beach, not sure the other name.
Okay. And somewhere in your file, there's a FACN plan for them, right?
I can't tell you that, just like I previously stated, I have not reviewed that part.
Do you have your file with you this morning?
I do not.
Where is that file?
Our files are electronic, and I don't have that with me today.
But you have access to it, you can go back and look at it?
Once I get back to the office, I can.
Okay. If there's an FACN report in this case that those doctors, Beach and Lahode, have reviewed the pictures and they say that they
Judge, I would object to anything about a report that's testifying about things not in evidence.
Judge, it's in the CPS file.
If it's in the CPS file, then it's the same as what I'll let you do. If it's in the CPS file and she has reviewed it, then she can answer those questions.
Is it normal, if there's an FACN report, is it normal to have to be in the CPS file?
We normally do upload it into our case. What I will tell you right now is the system that we upload into our one case is actually down, and our IT department is working on that. That's something they've been working on for a couple of days now.
So does that mean there's no way for you to review it today?
I would not be able not to review the actual report from the FACN, no, sir.
Did you speak with the investigator in this case, Officer Tassin?
No, he's no longer with the department.
If part of the report, part of the police report in this case, if that were to include statements from that FACN file, you would tend to agree, you would agree that those had to come from the CPS file, right?
That's possible, or they could have requested directly from Dr. Beach.
If they were given to the police department by Joshua Travesa, they'd be in the CPS file?
That should be in our file.
And if that FACN report says that the lesions that the doctors observed in the pictures appear to be associated with pruritus, which in parentheses is itching, you don't have any reason to disagree with that, do you?
I would have to see the report to be able to agree with it or not.
But if that's what the doctor says, you're not going to disagree with the
I
doctor,
would
right?
not if that's what Dr. Beach identified.
And then if that report goes on to say that it cannot be determined if the injuries were injuries with an implement such as a stick or by nails, either human or canine, you don't have any reason to disagree with that either, do you?
No, if that's what's in the report.
Okay. And if the report doesn't say anything about these injuries being caused by a belt, if that's absent, if there's nothing about that in the report, you don't have any reason to disagree with that either, do you?
Like I said, if that's what's in the report, I cannot disagree with what's in the report.
That's what.
Thank you, Mr. Rojas.
Ms. Henson, your agency didn't determine that those could have been caused by scratches.
No, we did not.
You didn't determine that those could have been caused by another child.
No, we did not.
You felt like those injuries were caused by Dalvius Williams, who is the primary disciplinarian for this family.
That's correct.
Mr. Rojas.
Your agency didn't make that determination, but you sent those pictures off to an expert who could make that determination, right?
We did send those documents off.
And they're the experts.
They are.
That's what.
Other property first.
Anything else, Mr. Rojas? Any objection to Ms. Henson? Sorry, Henson being excused? Any objection to that?
No objection.
Thank you, ma'am. You're excused. You may call your next witness.
That calls Detective L.D. King.
Do you have the cause number for the co-defendant, Ms. Broussard, by chance?
25 DCCR 0175.
Thank you. You may proceed.
Good morning. Would you state your name for the record and spell it for the court, please?
Leland, Leland, King, Keen.
And how are you currently employed?
I'm a detective with Beaumont Police Department.
How long have you been so employed?
25 years.
Are you a certified peace officer in this state?
Yes.
And how long have you been a certified peace officer?
30 years.
As part of your job description, you're given cases and you help investigate those cases, and then if you find probable cause, you bring those to the district attorney's office, and if they bring them to, they find it, they bring it to the grand jury, and those cases are indicted. Is that correct?
Yes.
In this particular case against Dalvius Williams, were you assigned as the investigator in this injury to a child case?
Yes, I was.
And what did you do after receiving this case?
Well, the case came in as a CPS referral, which is given to law enforcement with possible child physical abuse. Make contact with the investigator, received photographs of the injuries. Once I could see those, they were obviously highly suspicious of caused physical injury to the child. And so I began an investigation, and I began to talk to everyone that I knew was involved in the case, including, we had the children guard house and so forth. Spoke with the people at the school who witnessed and called us in, witnessed the initial injuries that they noticed. To include speaking with the victim child's mother and ultimately Mr. Williams as well, an interview with him.
Okay. Now, when you spoke to the mother, have you interviewed suspects and witnesses before?
Yes,
Is that on few or many occasions?
many.
Do you have, I guess, for lack of a better word, a feel for when somebody's being truthful with you and when they're not?
Yes,
Did you feel like Ms. Broussard was being truthful with you initially?
I did not.
Why not?
Well, what she was saying didn't match with what I knew at the time, the evidence. Some of her statements, such as "I never saw it," was incredulous given the extent of the injury. They're very obvious. She said things like, Mr. Williams wasn't in the home. We had indications otherwise. Ultimately, in that interview, she admitted that she was being untruthful, and then came to a different story.
Now, did it raise any red flags with you that the injuries were discovered on a Tuesday, the child had been absent from daycare on the Monday, and on Friday when he was there were no marks?
Sure, yeah, it's, in the case I've investigated of this nature, that's not uncommon. The child's at school, for there to be an event that occurs that caused injury to the child, and then you have an absence of some type for obvious reasons. And associated with these injuries, they could be seen above his shirt. It would be obvious to someone if they saw that. It also indicates the time frame of when this injury occurred.
After watching the interviews with the siblings, did you have any opinion based on your law enforcement experience about whether they were being truthful or not?
Yes, in my opinion, in my experience, they, in their statements themselves, appear to have been coached to exclude Mr. Williams from even being present, much less being involved in anything. And they admitted so. The second child admitted so.
So second child changed the story
Yes.
after a little bit of effort.
Right, yeah, she just kind of came out and said that, children that age their instinct is to be honest. They're not very good at being dishonest when they're kind of told to, so it just kind of came naturally.
And this wasn't something that you did as well. You're not interviewing the child.
No, it's at the guard house.
So this is a forensic interview.
Forensic interview, yes.
So initially, it seemed to you everybody was trying to protect Mr. Williams,
Yes,
but those stories eventually changed.
yes.
Did you actually have an opportunity to speak with Dalvius Williams?
Yes, I did.
Did you conduct an interview with him?
I did.
Was it a fairly long interview?
Yes.
Did you feel like Dalvius Williams was honest with you in his interview?
I do not.
Why not?
Well, for a number of factors. Given one, the way he described things is not what I recollect, and in my had collected in evidence and statements in the investigation. He made distancing statements, but he did, in the course of that, have some, I call it soft admissions, indicating his involvement in the injury to this child. He didn't come out and say he did it, but he did indicate there was an incident with this child where he was frustrated with him. It was his words. and, use physical, measures against the child.
Okay. Did you, but he came short of admitting that he actually struck the child. What did he say when he was making soft admissions?
He said he was frustrated over the child. I believe it was spilling water or something to that effect. And his words were snatched the child down onto the floor, and then became angry and snatched the child back up. He also said, which was kind of odd in the context, but whenever he goes too far with the children, disciplining them and injures them, he always cries. He also, we asked him, about directly, did you cause these injuries? His response was, I don't feel like I did.
So he didn't say, I didn't do it. It was, I don't feel like I did.
Feel like I did.
Did he express to you what his cause of frustration was?
Yes, because he said, now, of course, in the context, this is a 2-year-old nonverbal child, was insubordinate to him. And this issue with the water triggered him. And
Describe for the judge what incident with the water we're talking about.
what I recall is the child had there was some water that they had reserved for a specific purpose, and the child was either playing or spilled the water, and which they had reserved for something specific, and so that angered him, and that's how he reacted with it.
And he admitted that he grabbed him by the arm and yanked him up.
Yes.
And then he actually admitted that he grabbed him and yanked him again.
Yes.
Now, did you discover who the disciplinarian in the family was?
Yes.
Who was that?
Mr. Williams.
And how did he discipline the children?
With, they indicated, with a white belt.
So he would use a belt regularly in disciplining the children.
Yes.
And he admitted to you that he used that belt to discipline the children,
Yes.
but just said he didn't strike Xavier that day with the belt.
That's correct.
You've seen the photographs that were submitted with the case that have now been introduced into court.
Yes.
Do you feel like those marks were made by one of his siblings?
I'm sorry, the last part.
Do you feel like those marks were made by one of the siblings in playing, scratching, one of the
No, absolutely.
Desire, maybe in anger, made those marks?
No, I do not.
Do you feel like those marks were made by the child falling down a set of stairs outside the home?
Absolutely not.
Okay. Now, there's been some mention about a report. Y'all sent the photographs off for, I guess, a professional examination by...
Yes, CPS did. They sent the photos to forensic. It's FAC, and the whole name escapes me at the moment.
All right. Would you describe for the judge what that report, kind of just the gist of what they said?
The gist of it was within the context which she had, which was not my investigation, which was basically the photographs and the preliminary information from CPS. She described the marks as linear that could be caused by a thin object or scratches. She said it was, I'm sorry, the exact wording escapes me, but basically undetermined on physical abuse. And she asked, in the report, she said, if given more context, I can make a better determination.
So, based on that report, that didn't change your mind about what happened here.
No.
based on that report, it didn't change CPS's determination that abuse had occurred.
That's my understanding, yes.
But, and the photographs were the only evidence that was given.
Correct.
And the same photographs that we have here are the photographs that they had.
Yes, that's my understanding, yes.
And the way the injuries were described by Miss Herd, Shelby Herd, she described them as scratches and bruises.
Yes.
And Miss Wilson, Wana Wilson, who was the manager, she described them as whips and bruises.
Yes.
And you would describe them as what?
I would describe them as severe, indicative of an object that struck the child with great force that was either thin or the edge of something.
And do you feel like, after investigating Mr. Williams, that he is the one who caused those marks?
I do believe that, yes.
But I just want a look, if I can, if Detective Keene knows how many kids were in the house and what the relationship is.
Okay.
I just want to make sure I'm getting all the names right and who's
So
who.
there were, actually, Miss Broussard has, is it 6 or 7 children?
I don't recall, I think it's 7.
Are any of them, does Mr. Williams have any of his own children?
I
we know that?
believe 6 of the children.
I was looking at the prior PSI, and it was, I feel like it's missing all that information for some reason.
Well, there were 7 children in the home. I believe 6 of those children are his.
Is it right?
That's my understanding, Johnny, yes.
That's not right.
6 are yours.
There's only 6 in the house and they're all mine.
6 in the house and they're all,
6 of the children are his, for sure.
okay.
I believe, according to the investigation, 7 children actually were there.
Yeah.
There was an extra, okay. Okay. All right, got it. Thank you.
And do you recall what Mr. Williams said about the children's accounts of what had occurred as far as discipline and all that goes on?
I don't recall his exact words. I can refer back, but he was basically shooting down their credibility.
Let me show you page 8 of your report.
Right. Yeah. And yeah, he claimed that they were lying, and that they were all involved in the incident.
Okay.
That's what it is.
Morning.
Morning.
So it's your belief that Dalvius Williams caused these injuries by using that white belt?
It's my belief that Dalvius Williams caused those injuries. As to whether or not he used the white belt, I don't know.
And that's based on all the statements you got from everybody?
I'm sorry.
It's based on the statements you got from all the kids and from Mom, from Ms. Broussard, and CPS?
Yeah, it's based on totality of the circumstances and the facts and evidence that we gathered in the investigation.
You got Mom first saying that Dad wasn't around, Mr. Williams wasn't around, right? That's her first statement, that he wasn't there.
Yes,
Okay, you come to find out that that wasn't true.
correct.
Okay. The kids are saying, I think one of the kids first said, I don't have a daddy, right?
Yes,
And then that turns out that's not true.
of course, yes.
Okay. So Your belief is this happened over the weekend after school, after the daycare on Friday?
Given that he was observed no injury on the Friday and observed with injury on the Tuesday, I would surmise that it happened within those 3 days.
And who all was around Xavier from Friday after daycare till Tuesday when he's,
I don't know.
you don't know?
I mean, in my investigation, what I found by talking to everyone, there was no indication of no one else being there.
Xavier was alone?
I'm sorry?
Xavier was alone all this time?
No, I think he was with his Mr. Williams,
Okay. Who else?
Ms. Broussard,
Okay.
and his siblings.
Okay. So it's Mr. Williams there, Ms. Broussard's there, and 6 other kids are there. Or 5 other kids are there.
Yes.
Okay. And of all those people, you point the finger at Mr. Williams.
Yeah, I mean, I wouldn't care to point the finger at him. I think that the
Oh,
facts,
you charged him with it.
the facts and evidence led me to that conclusion.
What facts? I mean, what evidence says that he's the one that did this? Who saw him do this?
Well, glad you mentioned that. So one of the children,
Who
Desire,
saw him do this?
Let him answer. Go ahead.
thank you, Desire heard it occurring.
What did she hear?
She heard, what she described was him getting whipped inside the house.
Presumably by that white belt.
I'm sorry,
Presumably by that white belt.
I don't know that.
Okay, so Ms. Broussard was there this weekend too, right?
Sure, yes,
Okay. Did anybody ask whether Ms. Broussard did this? But she's charged with the crime, right?
she is.
Okay. So if you're so sure he did it, why are you charging her with it?
Well, Ms. Broussard was charged because she assisted him in the commission of the offense by lying, covering up, and so forth.
You don't leave any room for the possibility that she did this?
I do not.
Did you, during your investigation, did you have a chance to talk to the kids about, I'm gonna say it wrong again, Desire?
I'm a little.
Desire is one of the other children in the house, right?
Desire, yes.
Yeah, okay. Did you have talk to the kid, did you talk to the kids yourself at all?
No.
Oh, you didn't talk to them?
No.
Okay.
No, that's not our protocol. Our protocol is to bring them to have a forensic interview at the courthouse.
And you watched the whole Garth House video?
Yes.
Did Desire talk at all, or did anybody talk at all about Desire being, having violent tendencies and acting out physically against her siblings? Do you recall that in there?
It doesn't stick out to me.
Okay. And you discount, I mean, CPS sent these pictures off to the 2 doctors, right? The FACN report?
Yes.
And even though they're saying they could be scratches or itching, caused by fingernails, you disregard that. You're not interested in listening to that, are you?
No, of course not. But I think if you go further to what they said, and they said that some of that is scratching associated with the injuries, which, I mean, I'm not a doctor, but if I get an injury on my skin, I'm just going to itch as it heals. I don't think they were referring to the whole thing as itching. Also, I believe at the end of that, they indicated that without further context, if they had further context, then they could give a better pronouncement, which they didn't have the context when they reviewed that I have with the full context of the investigation.
And they based their opinion on the pictures that you sent to them, right? Or the CPS sent to them?
As far as I know, yes.
And those are the pictures that were taken immediately after this case, the report was made?
Yes.
So they're mentioning scratches, but fingernails, itching. There's no mention in the report about bruises.
Well, if I can refer to my notes.
Sure.
I think she said that what I have in my notes is the marks appear to have been caused in a similar manner, but it cannot be determined if the injuries were caused with an implement, such as a stick, or by the nails, human, canine, or other.
Right.
The findings are non-specific or child abuse.
And that part, at the very top of that paragraph, the second sentence, some lesions appear to have associated I can't say that word, pruritus. Itching,
Yeah. So
right?
some lesions appear to have associated pruritus, itching, based on other associated superficial marks present in the area. I don't think she was saying that those are itching injuries. I think she was saying there were superficial marks adjacent to the injuries that appear to be from itching.
But she's not saying there's any welts, or is she? There's no welts. She didn't say anything about welt marks, right? Does she?
I don't know.
Does she say anything about, do you have anything about welt marks in your report?
No, I've never seen a
Okay.
physician use that language.
Do you have anything about bruising in the report that she made to you?
No.
All we have in her report, the expert reports, is itching, maybe made by nails, canine or other, right? That's
No.
all we have. That's not, what else do we have from the expert then?
I'm sorry?
What else do we have from the expert?
Okay, so I think you said just itching
That's,
and
I'm
nail marks.
asking,
And
I'm asking.
so if I could read again, she stated in my notes, the marks appear to be caused in a similar manner but cannot be determined if the injuries were made with an implement, such as a stick, or by the nails, human, canine, or other. These findings are non-specific for child physical abuse.
It doesn't say anything about whether they could be caused by whipping, either with a belt or with a hand, right?
No.
Okay. And that's the allegation, is that he whipped, because somebody heard some whipping going on, right?
That's one of the things, yes.
And that's just one of the things?
Yes.
But the doctor doesn't say anything about whipping, she says scratches.
And I think
I mean, that's,
I'm not the doctor, of course,
okay.
but I do believe, like I said before, the doctor did not have all the information that I had in the investigation. I think she had a photograph.
What other information did you have that would have been helpful to the doctor?
Oh, well, in the context of the whole thing, I mean, you
I'm
have.
talking about to determine how these injuries were made, just based
Sure.
on.
Yeah, sure. You have the children, especially Desire, who heard this, who also stated that in her interview that Mr. Williams had whipped her on her back in the past in Houston. You had the Mr. Williams statement himself talking about snatching the child, being angry that he didn't feel like he could have caused those injuries, but indicative of a violent act that occurred between Mr. Williams and this 2-year-old child in the time period in question.
Okay, so he whipped another child in Houston a few months back, right?
I don't know the time frame, but that's what she said.
In Houston.
They lived in Houston. I don't know when that was.
And Mr. Williams agreed that he snatched the child up by an arm, right? That, and if you would have given that to the doctor, that would have helped her to make a better determination?
Well, I would assume, but I'm not the doctor.
But it wouldn't have changed. She still, if there were welts in the picture, Mark, she would, if there were welts in the picture, she would have said there were welts. If there was bruising, she still would have said there was bruising, right? That piece of information is not gonna help her see the pictures any better, right?
Yeah, I can't answer that for you. I can just say, but I would think it would, yes. She seemed to indicate that it would.
Pass this.
Just this time, we kind of referred to it, and I figured we'd just soon put it into evidence, the actual report from Dr. Meeks, so that you can have it for your.
No objection.
What's it marked as? I'm sorry.
State's Exhibit number 8.
All right, and no objection to state's 8.
No objection.
It's admitted.
refer to that, Judge.
Yes, sir.
So as you said, it's your understanding that the only evidence that Dr. Veach and Dr. Lahode had were the photographs that CPS sent them.
To my knowledge, yes.
And these findings are non-specific for child physical abuse. Additional history or findings at the scene, if available, might provide more clarity.
Yes.
You feel like you had the other evidence that would give you more clarity as to what happened in this particular case.
I did.
Is there any doubt in your mind that those marks on Xavier's back were caused by Mr. Williams?
I have no doubt.
Could Xavier himself have caused those marks?
No.
Could he have scratched his back himself?
No, I mean, given the location and the angles of the wounds, I don't see how that's anatomically possible.
And those marks cover a fairly large portion of his back, and in
That's
places where his hand wouldn't even reach.
Right, top, or bottom of the neck, right at the top of the back, all the way down to past his mid-back.
That's
So if he couldn't scratch his back, somebody else had to do it. Right?
Can you clarify?
Mr.
Sorry.
Smith just asked you if Xavier could have scratched those, made those scratches marks himself. You said it's anatomically impossible, or some force that he couldn't reach.
In my opinion, yes.
Okay, so if he didn't scratch himself in the back, and there are scratches on him,
Well, we don't know if they're scratches.
if the doctor says they look like scratches,
That's-
okay, then he didn't scratch himself, right?
That's,
That's not what she said.
He can't reach back there to scratch himself, right?
I mean, you could probably do this.
Well, so now he can?
He's two.
Okay. So, if there's scratch marks on the back, if they are scratch marks, can we agree that Xavier didn't do them, do them himself?
I'm not sure I can answer that. I don't believe those are scratch marks.
Okay. But he couldn't reach back there and do that, right? If he was scratched, if he wanted to, because earlier you said it could be associated with discomfort, he wanted to scratch the bruising or whatever his back, he wanted to scratch himself because there was discomfort. Do you remember testifying about that?
Can you say that again? I'm sorry, I'm a little hard to hear. I apologize.
I think earlier you said that, when we were talking about the doctor's report, you said that if there were scratches, you said that could be associated with some discomfort. She's trying to scratch the injuries because he's uncomfortable.
Oh, like healing or something?
Right.
Right, yes.
Okay, so according to what you told Mr. Smith, if that's the case, if they're healing, if they're uncomfortable, he couldn't scratch himself, or he couldn't reach them, is what you told Mr. Smith.
What I said was, the totality of it, no, there's no way. I don't see how he could possibly do that, given the entirety of his back. I think he could reach probably right here, I would assume, which I believe is where she indicated she saw those associated, adjacent to the injuries appear to be.
So now, just to be clear, you're changing your testimony to say that, yeah, you believe he can reach those injuries.
I'm not changing it.
You told Mr. Smith he couldn't reach them, now you're saying he possibly could.
said he can reach some of them at the top. Move on.
That's what.
All right, thank you. Anything else, Mr. Smith? All right, any objection to Detective King being excused?
No, Your Honor.
Mr. Smith?
No.
Thank you, Detective.
Thank you.
Any other witnesses?
Not from the state of this,
All right.
this time.
All right, Mr. Rojas, you may call your witness.
Dana Williams, Your Honor.
Dana Williams. You can come on up and have a seat right here, ma'am. And Ms. Williams, if you'll just pull that microphone, where you can get it as close as you can, and be sure when you're answering the questions to answer loudly and clearly so everyone can hear you. Also, if it's a yes or a no question, be sure to say yes or no and not just a head nod or an uh-huh, so the court reporter can take everything down. Thank you. You may proceed.
Would you state your name for the record, please?
Dana Williams.
And Ms. Williams, what is your relation to Dallas Williams?
I'm his mom.
And so that would make you the grandmother to Xavier.
Yes, sir.
Okay. And since this incident happened, that we're talking about here today, CPS has gotten involved and they've actually placed the kids with you, right?
Yes, sir.
And how many kids are living with you right now?
6.
All of Dalvis's kids are
All
living
of David's kids are living with me at this time.
with you? Okay. Since Dalvis has been in jail, actually, when did they first place the kids with you?
They placed the kids with me February, I got them on the 17th, but they wrote it up on the 19th of this year.
Of this year, so about maybe 2 months they've been?
Yes.
Okay. And you've had a chance since they've been living with you, and before also, I'm sure, but since they've been living with you, you've had a chance to observe their behaviors.
Yes, their behaviors.
Okay. I'm gonna talk specifically about Desire. Okay, what kind of a child is Desire? How old is Desire right now?
Desire is 6 right now.
Okay.
And what kind of child she is?
Yes, ma'am.
She's a very aggressive child. I've been taking her to spinal tap and had her diagnosed. She has a couple of disorders.
And do you know what those disorders are?
I have paperwork over there. I just set my book down.
Okay.
But
Just,
I know one of them is an opposite deficit mood disorder that causes anger issues.
okay. So let's talk about the anger issues. Have you seen her have anger issues before?
Yes,
And when she does have anger issues, what kind of behavior does she display?
she attacks it. She attacks the other kids, and she also harms herself. She hits her head against the wall. She throws things in,
Okay.
screams.
And since the kids have been living, or I guess since Dalvis has been in jail, have you had a chance to observe marks on Xavier?
Yes,
Okay, and did you take pictures of those marks?
yes, sir.
Can I approach with it, Sharon?
Yes, sir.
I'm gonna show you what's been marked, Defendant Exhibit 1. Do you recognize that picture?
Yes, sir.
And is that a picture that you took?
Yes, sir.
And is that a picture of Xavier's back?
Yes, sir.
And that picture was taken on November 17th of 2024?
Yes, sir.
And is that a fair and accurate depiction of what Xavier's back looked like at that time?
Yes, sir.
And I'll show you what's been marked as Defendant's Exhibit number 2. This picture looks like it was taken on December 4th of last year. Is that also a picture of the lower back of Xavier?
Yes, sir.
And you took this picture?
Yes, sir.
Is that a fair and accurate depiction of the marks on his back at
Yes,
that
sir.
time? I'll proceed on Defendants 1 and 2. Your Honor.
No objection.
Defendants 1 and 2 are admitted.
Which one is the one with the, what number is this one? One?
This one's 1.
Okay. One of those pictures is a picture of, and I'll show it to you again. Defendant's number 1 is a picture of his back. Looks like to be the upper portion of his back.
Yes, sir.
And what is that on the?
That was the first day it was taken. I caught it the day of when she scratched it. So that one, the second one is like days after.
Okay, so Defendants 1, these are pictures that were taken the day that those scratches appeared.
Yes, sir.
Okay, and you say that you took them right when she scratched them. Who is she?
Desire.
And how do you know that Desire scratched him?
Because I seen them fighting and he bit her and she scratched him.
Okay. Now, these were taken in November before the kids were moved into your house, right? Or
Yes.
November and December. Why did you come to be around the kids at that time?
I babysit the kids a lot of times when mom had things to do.
So was this before CPS got involved in the case
Yes,
and had the plan of service?
yes,
Okay. So those scratches is your testimony that those scratches were caused by Desire?
yes.
And you saw her do them?
I saw her do the first one. The
Okay.
second one, I caught it days out.
Okay. And is this typical behavior that you were used to seeing from Desire?
Every now and then she has issues, yes.
Okay. Now, you know what this new allegation is against Dalius, right?
Yes, sir.
Do you feel that the scratches that we're here talking about in this case, that is the basis for this motion to revoke, do you feel that those scratches were also caused by Desire?
The way the kids are, they fight a lot. So I can not say she exactly did it, but I can say that they fight,
Okay.
all of them.
And what kind of, so the kids are living with you, the mom is Ashley Russo?
Yes, sir.
And what kind of visitation does Ashley have with the kids?
Right now, she's able to see 5 of them with approval, supervision from the CPS people. Certain people can watch her watch the kids,
Okay.
but it's able she cannot have any contact at all.
She has no contact with Xavier, and supervised visits with the other 5 kids.
Yes,
It's supervised by somebody other than you, or?
other than me, because I have Xavier at all times besides when my ex-husband killed.
Okay. Pass witness.
Thank you, Mr. Rojas. Mr. Smith?
No questions, Mr.
All right, thank you, ma'am. You can step back out. Mr. Rojas, any other witnesses?
No other witnesses, Your Honor.
Any rebuttal?
Nothing to say.
Okay. So I want to make sure also for the record, what all I've reviewed. The original PSI, obviously from being placed on probation, is included with the updated pre-sentence report. Everyone should have that as well. And so when I went back through that, I just want to make sure that there aren't any corrections or issues with regard to that criminal history specifically that I'm looking at. Starts on page 1 and then carries on to page 2 on that pre-sentence, or actually it was a post-sentence investigation, I think. Y'all have that? Everybody's on the same page as me?
Yes, Your Honor.
So it looks like there was adult misdemeanor history of 2 thefts back in 2013. Both of those were 30 days in jail. There was a theft of services in 2014 where Mr. Williams received a probation. That probation was revoked in 2016. That's in Rusk County. Possession of marijuana in 2014, Nacogdoches, 3 months in jail. A resisting arrest or search, March of 2015, where there was a probation given that was revoked in 2018. There was then a 2015 failure to appear bail jumping case in Nacogdoches, 2016 burglary of a vehicle, 30 days jail, and then 2019 a resisting arrest again and an evading arrest also in 2019, both with 180 days in jail. Then the felony criminal history I show is a criminally negligent homicide from 2017, where a probation was given in 2018. That probation was revoked in 2020. Looks like that probation was revoked based on, and looking back on all of this, I'm not real sure other than what we were all thinking, but it looks like on January 10th of 2020, the probation was revoked on the criminally negligent homicide. There was a new offense of injury to a child that he appears to have pled guilty on and received a 12-month state jail sentence. There was another offense, new offense from January of 2019, an attempt to take an officer's weapon, also same disposition date of January 10th of 2020 for the 12 months in the state jail. And then there was this possession case that we're here from that same date. So it looks like he took some time on a couple of things and then got probation on the possession. Does that, everybody on the same page as that?
Yes, Your Honor.
I did look back. I think because I have this information, I don't think it's necessarily improper for me to look at some of the information based on those cases. I do have a question specifically with regard to the injury to a child from 2020 that he pled guilty on. What is the relationship with the Kaimani McHenry? That was the victim in that offense.
It's the stepson, Your Honor.
So Ms. Broussard has other children
Yes.
that are not from Mr. Williams.
At least one, Your Honor, yes.
Kaimani, is that the only one? Okay. And so I've reviewed so let's go back then to the motion, second amended motion to revoke unadjudicated probation that we're here on today in cause number 19-32623. So when we went back through, Mr. Williams entered pleas of true to counts 1 and 2. So I am going to find based on those pleas, counts 1 and 2 true. Count 3 entered a plea of not true, as well as on count 4. I am going to find, based on the evidence presented today with regard to count 4, that there is sufficient evidence to find count 4 true, and at this time I am going to find count 4 true. I understand everyone's position. I think with regard to, there'd be different evidence, I would think, and probably more potentially at a trial. I'm not required to look at all that, and obviously the level of the burden is different. So count 4 is true. Mr. Rojas, you may proceed with argument.
Judge, when we did the initial plea, we got the updated PSI report, and they were recommending that if probation were to be granted of ISF. Obviously, that can't happen with a new charge pending. He does have this new injury to a child that after speaking with the family, I don't think he's going to be able to bond out even if you were to keep him on probation. If the court is inclined to keep him on probation without ISF, we ask you to do that. If that's not going to be possible, Judge, we ask the court to consider something in the range for the possession case, 2 to 4 years.
All right. Thank you, Mr. Rojas.
Judge,
Mr.
I
Smith?
believe his criminal history shows fairly convincingly that he is unable to successfully complete probation. Speaking of probation officer, I don't believe it's their desire to keep him on probation with this type of charge pending, especially in light of the fact that he's already been convicted of injury to a child within the last few years. That tends to me to show more than just a pattern, it's a habit. The fact that he doesn't respect authority is shown by the jail incident reports. I feel like he needs to be revoked in this particular case, and we're asking for no less than 5 years, somewhere between 5 and 10 years as punishment in this particular possession case.
Thank you. And also, just for the record, everybody has those jail incident reports. Those were provided. I've reviewed those as well. Mr. Barksdale's here. Mr. Barksdale, do you, the probation officer, do you have anything to add at this point with regard to your position?
No, ma'am, I concur with the district attorney.
Okay, thank you, sir. Mr. Rojas, I would give you an opportunity if you want to. We can ask Mr. Barksdale to come if you have any questions of him.
No, Judge.
Okay. And Mr. Williams, you're 30 years old?
Just made that one.
You just turned 31. So I appreciate that you have support here and people here to support you, but your behavior to me tells me that you shouldn't be around any children, much less your own. Whatever is happening with you when you're getting angry at these children with what you're doing, because it's the same. This appears to be the exact same type of incident that you pled guilty for a few years ago when I put you on the probation for the possession. And this, it's ridiculous. You and Ashley both don't need to be around any children. Don't need to be having more children. You can't take care of your own children, and you're disciplining them by doing this. And I don't think there's any reason for anybody to believe that no one said these are scratches. That's not what the doctor said. If there are, they're adjacent to these other marks on the back of this 2-year-old. Going to find, again, that you entered your plea of true to counts 1 and 2 freely and voluntarily. Find those counts true. Find count 4 true. Find sufficient evidence at this time to find you guilty of possession of a controlled substance. I'm going to sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification. I'm making a notation on this because originally it was a plea agreement that when it was signed, I'm making a modification. Let me change it. This was not a plea agreement, so you do have some rights to appeal. I'm also going to hand you a written admonishment regarding, hold on a second, regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. Thank you all. I'm sorry. I know this is difficult for everyone, but I have no doubt in my mind that Mr. Williams, not just on this occasion, but probably on many, has obviously improperly disciplined, if that's what you want to call it, all of these children. So, court is adjourned.
All right.
Thanks for watching. Make sure to hit that like and subscribe button for more crazy court hearings like this one.